Well, to get some reaction to the story, we're joined by Lawson Naidoo from the Council for the Advancement of the South African Constitution. Mr. Naidoo, thank you very much for your time here on All Angles. I don't know what you make of the Public Protector's response to the President. She was, of course, given 10 days to let him know. She gives 12 reasons. The first one, she says it would be illegal for him and he should try and stay away from the processes. She mentions Busasa. I thought she lost that case all the way to the Constitutional Court in terms of that report into the CR17 donation.
Good afternoon, and thank you very much. I think, firstly, it's entirely unsurprising that the advocate Mkhwebane has taken this course of action. It was to be expected that she would challenge the notice of suspension served on her by the President. The President is acting in terms of the powers vested in him in terms of Section 194(3) of the Constitution, which gives him the power to suspend the head of a Chapter 9 institution once a formal inquiry is underway in Parliament, which it is. It's also important to note that the independent panel that Parliament assembled has already found that there is a prima facie case for the Public Protector to answer. So there are grounds for the inquiry to continue, as well as for the President to issue this suspension notice. This is very much an issue about accountability and the need for heads of Chapter 9 institutions to be held accountable when they fall short of the standards that are required from them in terms of the Constitution. And we've seen from Advocate Mkhwebane's attitude from the very moment that the parliamentary process was instituted in February 2020, this Stalingrad tactics that she has employed in order to evade accountability by Parliament. She lost a case in the Constitutional Court recently and has expectedly launched a rescission application in respect of that judgment. And that's really a sign of desperation that she's seeking to avoid at all costs having to account to Parliament for her many failures.
In this letter, I don't know, Mr. Naidoo, if you've seen it. I'm looking at it at the moment, and as I read it, it seems as though the Public Protector and her lawyers are basically saying that this is the President versus our client because of the fact that she actually instituted an investigation into the donation by Busasa, that CR17 500,000 Rand donation allegedly by Busasa. It shows from the President's response since then that the investigation actually even took place, that this has everything to do with that, and therefore he should withdraw from the processes. So I don't know what you think. It looks to me as though she's saying, no, the President is just doing this because he's upset with me for even investigating him at all.
Well, as I said, there's already been a preliminary process in Parliament to investigate the substance of the complaint against Advocate Mkhwebane. That independent panel has found that there is a prima facie case for her to answer. The Busasa matter is now well and truly over. The Public Protector launched a rescission application in respect of that judgment from the Constitutional Court, and she failed in that regard. And the broader point that needs to be made here, even if there are any legitimate investigations that are ongoing that may involve President Ramaphosa, it is entirely appropriate for the Office of the Public Protector to continue with those investigations. This is not a one-person show. There is a whole Office of the Public Protector, and if the head of that office is suspended, it does not mean that the investigations that may be conducted legitimately by that office must also cease. There is a Deputy Public Protector. There are teams of investigators who can continue any, as I say, legitimate investigations that may involve the President. So that's an argument that I don't think that, holds any water whatsoever. And this is really just a desperate attempt by Advocate Mkhwebane to evade the responsibility, to try and avoid having to account to Parliament for the transgressions she has been responsible for, and to try and ensure that she sees out her term by dragging these matters through the courts until October next year.
I was actually going to go to that point, and I found it very interesting during a visit to a place where she was investigating service delivery there. She actually said to journalists that she's going to serve until her term is done. And I was going to ask you about whether or not she's using the courts and the law to try and prolong this suspension from happening, because in the letter, quite interestingly, her lawyers say at this stage we are instructed to demand, as we hereby do, that the president must completely step away from this process. They also say that he must respond to they ask for him to step away by the 23rd of March. That was yesterday, by close of business yesterday. Otherwise, legal processes will be instituted against him.
Well, as I say, it's entirely to be expected that this would be the approach taken by Advocate Mkhwebane to try and embroil the matter in further legal processes, which will hopefully, from her perspective, draw it out even longer and prevent Parliament from conducting its inquiry into her misconduct, a matter which Parliament itself has set down for the ad hoc committee to start its work at the beginning of May. And, I think one will need to see how the courts respond to any urgent application that she may bring, and whether the courts will indeed actually entertain such an application, given that, as I say, the president is acting clearly in terms of authority that the Constitution grants to him.
I do still wonder why, Mr. Naidoo, she had to, make most of her 12 reasons about the Bosasa investigation that, as you rightfully said earlier, is already water under the bridge. She lost it all the way to the Constitutional Court, but she's still making this part of the larger reason why she feels the president shouldn't fall part of the process. So if I'm reading it correctly, is she probably saying that I don't have a problem with you going, with Parliament or the National Assembly getting into the processes of possibly suspending me, but I want you to withdraw yourself from it because you are tainted, because you're upset with me for investigating Bosasa and the 500,000 rand. Is that what she might be saying?
Well, I think that's a generous interpretation of what she might be saying. I think her strategy all along has been clearly to avoid having to account at all, to the National Assembly, as she's required to do in terms of the Constitution, and now to avoid having to face the consequences of action that the president is rightfully taking, because the conduct of the public protector is bringing the office of the public protector into disrepute, and she needs to be suspended pending the outcome of this parliamentary process. That's a normal state of affairs when there's a serious investigation being conducted against an incumbent. And this is, just a ploy, as I say, to evade accountability. And the public protector needs to understand that she operates within the context of the Constitution and needs to be accountable for her conduct. Her strategy is to try and avoid that accountability at all costs and to try and be able to see out her term of office. That would be something that would be very damaging for our democracy and entirely damaging for the office of the public protector, which is, after all, there to protect the interests of the citizens of this country.
All right. Thank you very much for your time, Mr. Lawson Naidoo. He is from the advancement of the South African Constitution.